everybody. Thank you so much for joining us for today's regional webinar on the impact of recent USCIS Policy Manual changes on immigrant survivors. My name is Kelly Byrne. If you don't know me, I'm ASISTA's OVW staff attorney. So I work primarily with OVW, LAV, and STOP funded organizations to provide training and technical assistance on legal issues affecting immigrant survivors, principally UT and VAWA forms of relief. And I'll turn it over to my co-presenter, Christina.
Thank you, Kelly. And thank you, Shannon. I'm Christina Velez, and I am the Legal and Policy Director of ASISTA. I use she, her pronouns as well. And I cover a range of our work here at ASISTA, including keeping abreast of policy changes, of which I know we're seeing a lot of these days. Happy to be here with you all.
Thank you, Christina. Could we go to the next slide, please? So this is just the OVW disclaimer. We thank OVW for their support of our training and TA work. Without OVW, today's webinar would not be possible. And just a reminder that the opinions, findings, and conclusions and recommendations in this webinar do not necessarily reflect the views of the Department of Justice. Next slide. So for our learning objectives, we have 3. The hope is that by participating in this session, you will be better able to describe USCIS Policy Manual changes about VAWA Self-Petitions and 8 U.S.C. 1367, the confidentiality and non-disclosure statute, to determine how USCIS might adjudicate certain case types after implementation of those new changes, and to adapt your practices to these new requirements. Next slide. So we'll start with VAWA self-petition changes, and then kind of folded into that is some guidance on how to enhance an adjudicator's perception of a survivor's credibility. We'll break for some questions, and then Christina will take us through some changes in USCIS's interpretation of 8 U.S.C. 1367. So, of course, the statute itself has not changed, but there has been a pretty dramatic change in how USCIS interprets it. Then we'll have more time for Q&A, and then we will move to takeaways. Next slide, please. Okay, so we will start with the VAWA self-petition policy manual changes. So these came out very conveniently right before the holidays, December 22nd of 2025, and they were effective on that same date. So there was no grace period, and they also applied to pending petitions. So these apply retroactively. Next slide, please. So in the policy manual, USCIS did concede that the any credible evidence standard, which many folks are probably familiar with from VAWA self-petitions, they've conceded that it is statutory, but they have really honed in on their discretion, which the statute does say does give USCIS a discretionary role, and that's really what USCIS is honing in on here. They've noted that for evidence to be credible, it has to be externally and internally consistent, plausible, and sufficiently detailed. So we've always encouraged practitioners to submit detailed and specific affidavits from survivors. So we've always encouraged that even before these changes. But that's even more important to do now. USCIS also now says that affidavits generally should contain extensive detail about the affiant, including their address and their place of birth. So imposing these new requirements on affidavits, which are important to keep an eye on. They've also stated that they will give less weight to affidavits that lack this information. And you'll also see that USCIS has placed a lot of focus in these updates on corroboration. which can be difficult, right? It can be difficult to get corroborating evidence, particularly if the abuser isolated the survivor from friends and family as part of the abuse, if the survivor was too afraid to seek help from systems, like the courts or the police. So recognizing it can be difficult to get this corroborating evidence. Um, but if you can't, um, just important to know that especially under this guidance, these are going to be more difficult cases to win in the future. But if the survivor wants to move forward despite the risks, you can push back on the corroboration requirement. You can argue that, the statute itself doesn't require corroboration, a bright line rule that corroboration must be in every case, that would be ultra vires to the statute, and also that evidence that is detailed and internally and externally consistent is still credible. So you want to do everything you can to make the evidence that you do submit as credible as possible. So that means if survivors submitting an affidavit, you want to make sure it's consistent with what you've submitted previously to USCIS, for example. USCIS has also imposed new requirements on photographic evidence, including a requirement to identify the photographer and to state where and when the photo was taken. Um, to be honest, this isn't like it's a change, but at the same time, I had seen USCIS say things about photographic evidence even during the Biden administration, like cast doubt on photographic evidence. Um, so it seems to me this is more just putting in guidance what had already been the practice. But just important to know that submitting photos without captions and without this detailed information, absent an explanation from the survivor of why it can't be obtained, is going to be a problem for VAWA cases. There's also a lot of language on psychological evaluations, which are not required and important not to be like forcing survivors to get those evaluations. But if you do submit them, there is a lot of new requirements that they're placing on those evaluations. So they want there to be proof that the person who's performing the evaluation either is treating the survivor, so like the survivor's therapist or counselor, or that they, quote, thoroughly and adequately evaluated the survivor. So when you're communicating with evaluators about parameters for the evaluation, it's important to communicate that requirement to them that there has to be some sort of evidence, either of the treating relationship or that this was a truly thorough evaluation of the survivor. Um, and keeping with that emphasis on detail, really important for evaluations to contain sufficient details and that the evaluator explains how their professional training and experience led them to any diagnoses. So not just simply listing the diagnosis, but explaining what were the circumstances that led them to that diagnosis. There's also a requirement that you include the evaluators, either their CV or their professional certifications, like their licensure information. So that's just important to keep in mind that you start asking for that from evaluators. Um, if evaluators won't give it to you, perhaps you can ask them to write something to that effect. Like that's not something that they give out, but otherwise, going to be an issue if you don't have that. Um, in terms of if there were prior fraudulent documents submitted, so USCIS, in terms of their new emphasis on fraud, they've noticed that the survivor submitted a fraudulent document in the past, or if they've made a false statement to USCIS in the past, that would undermine the credibility of all of the evidence. So even like the evidence, that is true, they would still, the fact that there was that fraudulent statement in the past, they're saying that would undermine the credibility. Um, Again, this isn't exactly new. Like I've seen at least one example during the Biden administration where the person had a past history of a fraudulent statement and then they used that against them in the VAWA. But the fact that they're taking the time to put this in guidance that is universally available to everyone shows that they're having um, a stronger emphasis on fraud. So for survivors who have committed fraud or misrep, which it happens, especially if it's part of the abuse, just important to keep this in mind that you're going to have to do even more to show that the evidence that they have submitted is credible. So focusing really on the details, making sure that any inconsistencies are explained. If certain evidence can't be obtained, making sure the survivor is explaining why that can't be obtained. Um, and if the false statement was connected to the abuse, having the survivor explain in their affidavit, like how the impact the abuse had on them, what they thought would happen if they didn't make the false statement. So, really painting that picture that there is that connection to the abuse. Um, and then in your cover letter, you could argue that if there was a connection to the abuse, that false statement was not voluntary, and really only voluntary false statements should have an impact on credibility. And since it wasn't a voluntary false statement, because it was connected to the abuse, they shouldn't say that that negatively impacts the survivor's credibility. Argument isn't tested anywhere, but it's helpful to include. Um, and then also kind of a Hail Mary argument, like you don't want to be relying on this, but that a prior misrepresentation, even if it's not connected to the abuse, shouldn't prevent the approval of a self-petition because Congress specifically created a fraud or misrep waiver of inadmissibility for VAWA self-petitioners applying for adjustment. And the fact that they created that waiver shows that obviously they anticipated that some people with that ground of inadmissibility would have approved VAWA self-petitions. Otherwise, they wouldn't even be able to be eligible for adjustment of status. So you can argue that the fact that that waiver exists shows that there is congressional intent that the mere fact of inadmissibility under that ground should not prevent the approval of a self-petition if the remaining evidence in the case is credible. Next slide. Um, so evidence of qualifying relationship, a big change is a requirement to submit evidence of the termination of the abuser's prior marriages. So, I mean, if the survivor was married before, obviously you would always want to include evidence of termination of that marriage, but it's new saying now you have to submit it for the abuser as well. And we have seen some reports on the listserv that this has started happening. If this has happened to you, please feel free to let us and your fellow attendees know about it. In the chat. There's a host of problems with this requirement because obviously because of abuse, often it's going to be difficult to get proof of termination of an abuser's prior marriages. But you could consider if you can't get that divorce decree or death certificate, the survivor should explain why. And then you can consider alternative ways to prove termination if the survivor doesn't have access, um, such as maybe people who know both the abuser and the survivor. If it's safe for them to do so, maybe asking them to write a statement saying that, they know that the abuser was divorced before they married the survivor. Or if the survivor um, knows their officiant relatively well, um, they would, have the officiant write a statement that they would not have married this couple if the abuser, wasn't divorced beforehand. Um, and then you also, ideally, if this is your situation, when you can't get primary evidence of the termination of the abuser's marriage, the survivor in their statement should have facts that support an intended spouse argument as a backup, because the intended spouse eligibility for a VAWA self-petition, luckily is statutory, so that can't be changed by the policy manual. So you would want to make sure that the survivor's statement has evidence supporting all of the elements. So one would be that the survivor believed that they did marry the abuser. That was their subjective belief. Number two, that there was an actual marriage ceremony between the abuser and the survivor. Um, Three, that the survivor subjectively really did believe that the abuser was free to marry them at that time. And four, that the only reason the marriage is invalid, I think they can maybe say potentially invalid because you shouldn't have to concede that it's invalid. But the only reason it's invalid is because of the abuser's bigamy. So there was nothing, you wouldn't be able to use this if also the survivor, had contributed to it, like the survivor wasn't divorced first. But if the only reason why it's not valid is because of the abuser's bigamy, as long as those other elements are met and you have evidence of that, survivors should be able to qualify on the intended spouse basis, even if they can't get that evidence of termination of the abuser's prior marriage. Um, you'll also see for birth certificates. So this is most applicable for either child self-petitioners or parent self-petitioners who were abused by adult U.S. citizen sons or daughters. There's this new language about birth certificates. So just keep in mind that if you're using a late registered birth certificate to prove the relationship between the self-petitioner and the abuser, um, try to get secondary evidence as well, like hospital records or a baptismal certificate. Um, or, those are ideal, but if you can't get that, then statements from people who were familiar with the circumstances of the birth and the relationship. And then the survivor should explain um, why the birth certificate was registered late. So it shouldn't be a de facto bar, and there is even some language in the policy manual recognizing that they can't just impose a bar because the birth certificate is a late registered one. It's going to be more difficult to prove that relationship. Next slide. Um, so battery or extreme cruelty. A very big change with this update is USCIS is now saying that the abuser must have been a U.S. citizen or an LPR at the time of the abuse. So they had not taken like a universal position on this question before. And actually, we would sometimes get TA questions about it. But now they're saying that the person must have been an USC or LPR at that time. Um, their only justification for that position is a BIA decision from 2021 that's in your materials called Matter of LLP. And that decision held that the abuser for a VAWA cancellation case, so it's not at all about self-petitions, it's about VAWA cancellation. They're saying an abuser in those cases must have been a USC or LPR at the time of the abuse. Important that the decision is about VAWA cancellation because if you're, kind of a nerd like me and you look at the way the two statutory structures are different, like the structure of the VAWA self-petition statute is very different than the structure of the VAWA cancellation statute. So it should not be the case that a decision that is based on a statutory interpretation of VAWA cancellation should automatically be applied to self-petitioners. Um, Especially without any reasoning. And USCIS provided no reasoning as to why they're embracing that decision. Um, all that said, though, USCIS is not going to buy those arguments. And if you wanted to challenge that, you would have to go to federal court. And in the meantime, if the VAWA was denied, the survivor would likely be NTA'd and potentially detained. So just important to keep in mind that while there are good arguments against this interpretation, um, USCIS is not going to buy them. The policy manual also appears to apply a stricter definition of battery or extreme cruelty, perhaps the most important criteria for a VAWA self-petition. It removed a pretty helpful and comprehensive list of examples of extreme cruelty. It removed that list of examples and instead cited dictionary definitions of the term batter that reference repeated blows, which is problematic. That's a pretty high standard. Um, and also a definition of extreme that includes the language to the utmost possible degree. So they appear to be interpreting these terms to require more serious behavior than I think that the statute intended. And certainly then they had required from the in 2022 when they wrote the Biden era updates. Um, the USCIS they helpfully did maintain the focus for extreme cruelty on is the abuser trying to attain compliance or control over the self-petitioner? So that is helpful, and you could still use that to help frame your presentation of evidence for extreme cruelty, so showing that this was the abuser's intent, and the survivor, maybe changed their behavior as a result of the abuser's actions. Um, but I think the overall message from this is that USCIS is moving away from survivor-centered adjudication practices that show an awareness of DV dynamics. We can no longer assume that VAWA adjudicators will have knowledge of those dynamics. So really important to include research materials on DV dynamics. Include the power and control wheel at a minimum with your submission. And that is going to be especially important if the case does not involve physical violence, because USCIS now I think is showing that they're going to be less likely to approve if there's not physical violence. It could also be helpful to include detailed letters of support from domestic violence advocates who the client has worked with, which contain specific information about the instances of abuse, and importantly, why the advocate thinks that this is domestic violence based on their training and experience. And that's especially helpful if there's acts that, a lay person might not think are abusive, but that we know are abusive, and that a DV advocate who is trained in these dynamics would know is abusive. Um, if the client has not worked with an advocate, but is willing to have some of their case files submitted to a DV expert, you could consider an expert affidavit. That might be especially helpful if the client comes from a community that has perhaps unfamiliar or more specific DV dynamics, like the LGBTQ plus community, where there's types of abusive behavior that you might not see um, in the cisgender or heterosexual community. So just important to keep that in mind. Next slide. Joint residence. So their new interpretation of this is a complete 180 from their interpretation in 2022. So now USCIS is saying that the survivor must have lived with the abuser during the qualifying relationship. So, for example, in a spousal VAWA case, that the survivor lived with the abuser while they were married. This was USCIS's position as well before 2022. And there was actually successful litigation filed against USCIS with this interpretation. And it's very possible that litigation could be filed again. I think this is also susceptible to arguments that this change in particular should not be retroactive because it is a really substantial change from the agency's prior position. And obviously, anybody who applied for VAWA after February of 2022 would have relied on the Biden era interpretation. Again, that's more of an argument for litigation. Like you could make it, I would say, make it to USCIS, knowing that they're not going to agree with it, but make it so it's in the record. But that is a potential argument for litigation. And keep in mind that if the survivor didn't live with the abuser during the qualifying relationship, there's a potential that they might still be eligible for VAWA cancellation because that form of relief does not have a joint residence requirement. Next slide, please. So good moral character. Some new language here is that USCIS says that conduct resulting in mandatory detention will be a negative factor in the GMC determination. And they don't distinguish between criminal and non-criminal bases. And as many folks probably know, there's the BIA decision saying that entering without inspection subjects someone to mandatory detention, and the Fifth Circuit has upheld that interpretation. So presumably, USCIS could say that if someone entered without inspection and was subjected to mandatory detention as a result, that could figure negatively in the GMC analysis, even if they don't have any criminal history. Um, USCIS has also noted that if the survivor doesn't disclose their criminal history, even if it's not relevant to eligibility, like for example, one arrest that did not result in a conviction and didn't involve, drug trafficking would most likely not be a categorical bar to good moral character, but they're saying that not disclosing that is going to be a good moral character problem. So important going forward. It's always important, but really important going forward to have a clear picture of the survivor's criminal history before you file, and that they disclose their entire history, or it could cast doubt on the credibility of the entire filing. Um, they've also emphasized, which I mean, they emphasized this before in 2022, but really even more so now, that they can consider acts outside of the 3-year period. So, like the VAWA regulations, the 3-year period comes from the regulations, um, which require, the submission of a police clearance letter for the past 3 years. So that's where the 3-year requirement comes from. But they're saying they can consider acts outside of that period. Um, especially if they're relevant to the self-petitioner's present good moral character. And they also say, troublingly, that passage of time alone might not be enough to demonstrate good moral character. Um, so just keep that in mind. If the past acts were related to the abuse or trauma, if the survivor has been rehabilitated and you have evidence of that, I would argue that they're not relevant to the survivor's present good moral character, and that they should not be considered, because they're outside of that 3-year period. Next slide. Another big change is that USCIS said in these updates that it may deny a self-petition without issuing an RFE first. So that makes it really important to include multiple pieces of credible evidence for each VAWA element at the time of filing, rather than filing a skeletal petition and then relying on being able to supplement later on. Um, Obviously, there are some circumstances where you might have to supplement, like if you're on a deadline, but generally, really important to file well-supported petitions at the outset, to avoid a straight denial, especially given the NTA policy. Um, Also removed language about helpful language about revocation of self-petitions. So now it appears that USCIS field office employees who conduct the 485 adjustment interviews, that they can revoke self-petitions. And they also removed the policy that forbade those agents from inquiring about the abuse. So there's no like policy to point to now that would prevent these officers from asking about the abuse. A couple things that you could respond with. Um, One is that the regulations generally require a notice of intent to revoke and an opportunity to respond. And I'm going to put that regulation in the chat box. I would go to every I would go to every interview with that citation. And if they try to revoke a self-petition on the spot, I would bring that up and also ask to speak to a supervisor. Um, and about re-adjudicating the self-petition, again, unfortunately, there's no longer a policy to point to that prevents that. Um, but I would focus on the fact that the specific facts of abuse are not relevant to a 485 interview, and that USCIS already had a chance to assess the survivor's evidence of abuse. Um, and then if the survivor has a therapist who would be willing to attest to the trauma it would cause them to have to recount acts of abuse in an I-485 interview. It could be helpful to bring in a letter from that individual to the interview. Um, and this unfortunately does not apply to, so there are some folks who are having these combined I-360, 485 interviews. So those interviews will ask about the abuse, and unfortunately it would be appropriate to ask about it in that setting. But if there's an interview just on the I-485, there's arguments that it's not appropriate to ask about the abuse in that setting. Next slide. So now we have a hypo. You could read it to yourself. You can also put me on mute if you read faster than I do. Devika entered the United States without inspection. She's married to an abusive U.S. citizen, Paul, and they share a 4-month-old child, Tyler. Paul told Devika that real mothers nurse and don't work, and that he would have her deported if she tried to get a job. Devika has issues with her milk supply, but Paul also refuses to buy formula for their son or give Devika money for formula. And desperate to feed Tyler, Devika shoplifted formula while Paul was at work. She was arrested, but the case was recently dismissed on speedy trial grounds. So the questions for folks to answer in the chat are, how might this arrest impact the good moral character analysis, and how would you discuss this with Devika? Give folks a few minutes to think about that. I have some thoughts, but Christina, first wanted to give you a chance to weigh in, just if there's anything you wanted to say.
Oh, thank
No
you,
pressure,
Kelly.
though.
Well, I was thinking that Devika's arrest seems related to some of the abuse that she experienced from Paul, given that he refused to purchase formula for them or give her money to purchase formula. And with the knowledge that she would otherwise be unable to feed her child.
Yeah, exactly. I think that makes a lot of sense. And I've seen some folks alluding to it in chat. Um, I think it's definitely really important to make sure that an arrest like this is framed as being a direct result of the abuse, the coercive control. Um, Someone said it will implicate good moral character. Be careful about not admitting to essential elements, right? I mean, I would argue that someone who just puts something in a USCIS filing, like they shouldn't say that that's an admission, because under matter of K, like they have to explain the elements in like a way that the person understands, like a lay person would understand, and then after hearing that, then the person has to admit to it. Um, Sometimes in interviews or in immigration court, they try to get a person to do that. But I agree, though, just generally trying to not get them to admit something, get her to admit to something she didn't do. So framing it as a result of the abuse, definitely important. Um, USCIS, though, probably will say that, like, the fact that she was arrested implicates her good moral character. So we've probably seen, even before, USCIS places a lot of weight on the fact that a police officer believed that this person committed a crime, and places a pretty high burden on folks to rebut that, even if they were not convicted of the offense. So it is something that you'll have to tackle. They might also allege that since theft is a Laken-Riley Act offense and David got entered without an inspection, they might say also, oh, mandatory detention, that's another reason to question her character. You could respond to that by noting that there's nothing in here that says she was actually detained, and the policy manual says conduct resulting in mandatory detention, not like subjecting or, making them subject to. Um, will that argument win the day? Probably not, but you could still make it. Um, I think also what's going to be really important is not only focusing on the connection to the abuse, but also providing very substantial evidence of positive equities if Davica decides to move forward, because there's a lot of language about how um, good moral character is a discretionary determination. So, like, the fact that it's connected to the abuse is very helpful to point out, but I don't think, especially in this administration, that's going to be enough to um, to get David gun approval here. I think it's going to be really important to include those positive equities evidence, because discretion is tightening across the board. That said, though, I would argue in your cover letter that the fact that there is a waiver of conditional bars to good moral character that are related to abuse, which actually there isn't even a conditional bar here because there's no conviction, but the fact that there's a waiver of that for arrests that are related to abuse, that shows that there's a congressional intent to treat good moral character issues that are related to abuse more leniently. So I'd put that in your cover letter as well. Um, thank you, everyone, for your participation. We'll go to the next slide. The retroactivity, unfortunately, the USCIS and probably at the Administrative Appeals Office level, like, they're going to say, like, this is retroactive, too bad. But if you have an eye towards taking this to a different forum, or if another attorney might do that in the future, or you want to preserve, the possibility of that, I think still important to make arguments in your cover letter about why these changes should not be retroactive, especially the joint residence change, because that again was just like a complete 180 from the prior policy. And I think there's really good arguments that there's reliance interests there, really strong reliance interests with that policy. Um, Here on your screen is a retroactivity tests that the BIA uses. Um, and they actually applied it. So some of you might be familiar with, there was a case, matter of Forjo, that came out earlier this year about 237A1H waivers for misrepresentation. BIA changed their interpretation of that statute, but decided not to apply that interpretation retroactively. So there's actually a favorable retroactivity analysis in that decision. And that decision is in your materials. So I would take a look at it to see how the test is applied, and you can potentially make similar arguments in your own cases. It is true that this test is for an agency rule, and this is technically not a rule, it's policy guidance. But I'd argue that ultimately, like, when you're talking about retroactivity, you're talking about fairness. In some sense, you're talking about due process with, notice, providing folks fair notice. Um, and because the ultimate question is fairness, and especially with the joint residence change, like, there is an unfairness in applying that retroactively. I'd argue that this test should still apply, even though it's just a policy and not a rule. This argument might not be, I mean, you could try it, but the argument might not be as helpful with the abuser has to be a USC or LPR at the time of abuse, just because they didn't actually have a policy on that. You might be with that better off arguing that they provided no reasoning for why they embraced a decision that is about a form of relief that is very different from the VAWA Self-Petition. Next slide. So practice tips. Again, I cannot stress enough the importance of submitting evidence about domestic violence dynamics in these cases, because we can't assume anymore that the adjudicators are going to know about DV dynamics, particularly when a case doesn't involve physical abuse. And corroboration, again, is going to be important. Even if you can't corroborate everything, even if you can corroborate, small things like the survivor's statement that they were at the doctor on a certain day, like even if you can provide corroborating evidence of that, that does help enhance overall credibility. So important to keep that in mind. And again, corroboration of even those little things is even more important if your only evidence of one or more of the elements is the survivor's statement, because in that case, that statement has to be like as credible as possible. And if you can show that the survivor is credible with corroboration, that's going to be helpful. Again, if the survivor can't obtain corroborating evidence, they should explain why in their declaration. Like to us, it's obvious that they can't obtain something because of abuse, but the survivor should always explain that in their declaration. And then also make sure you're reviewing filings for consistency. Again, this is something we've always encouraged folks to do, even before this administration, but it's going to be even more critical now because inconsistencies can affect the credibility of other pieces of evidence, and will be especially harmful if the only evidence of abuse that you have, for example, is the survivor's statement, and they think the statement's not credible, that's going to be a problem. So just make sure you're reviewing for inconsistencies, and that if they exist, that the survivor explains them. And on the theme of consistency, I know it can be difficult with I'm not sure if it's still happening, but the FOIAs being rejected for not having, for putting the attorney's address. But if possible, try to figure out what was filed previously with USCIS or with any immigration agency, because if the survivor says something that is inconsistent with what was in a previous USCIS filing, I think this version of USCIS is going to jump on that, and they're going to use that as an excuse to say that the survivor is not credible. So really important to know what you're dealing with and to be able to explain any inconsistencies. Going to be important to brief the reasons why the any credible evidence standard exists. Since USCIS had removed language that was previously in the policy manual that explained to adjudicators why this standard was created in the first place. So adjudicators no longer have access to that language. There is some legislative history that you can find on our website or on NUWAP, National Immigrant Women's Advocacy Project website, that might be helpful. And then with supplementing pending cases, since you have to show that the joint residence was during the qualifying relationship and that some abuse occurred when the abuser was a U.S.C. or LPR, make sure that you have your evidence helps prove those things. So not only did the abuser and the survivor live together, but that they lived together during the qualifying relationship. And if you've already filed the case and it's pending, would probably be a good idea to supplement, especially given this language that they could just deny without an RFE. And when you're supplementing, recognize it can be frustrating because they reject a lot of things improperly, but make it as clear as possible that it's a supplemental filing. Put the I-360 receipt on top. And then finally, if there's any good moral character concerns, again, include very copious evidence of positive equities. We unfortunately can't assume that the passage of time or connection to abuse will be enough to overcome that. Next slide.
Kelly, I think someone was asking for some examples of positive equities.
Oh yeah, good question.
Mhm.
So I think if the arrest was related to drugs or alcohol, if the survivor attended Alcoholics Anonymous or Narcotics Anonymous or got some sort of treatment for a substance use or alcohol use disorder, that would be helpful to include. Um, I think if the survivor has U.S. citizen children, always helpful to include their birth certificates. If the survivor is, even if they're not U.S. citizens, if the survivor is the sole caretaker of their children, um, helpful to include evidence of that. Ideally, it will come in the form of like a custody order, but if you don't have that, the survivor can explain why. Um, and if the other parent is abusive, I think that's also helpful to highlight that like the survivor is the only safe caretaker for their children. Um, if the survivor's children have any um special, medical needs or they get, occupational, physical, speech therapy, things like that. They have an IEP, and the survivor is, really important in terms of being able to advocate for their child. The survivor being here, I think that's really important. Um, those systems can be hard to navigate even for, folks who are not, traumatized and are US citizens. So the fact that a survivor is helping a child through that, I think is a really strong positive equity. Um, and if the survivor has, again, there's no requirement with VAWA for a police report or protection order. But if the survivor has helped law enforcement, I think that's a positive equity, especially if that agency will go to bat for the survivor and maybe write a letter about how helpful they've been to their investigation, how important it is for them to stay here in the United States. I see a question about, can you explain what you meant by conduct resulting in mandatory detention, going to good moral character? So what they mean by that, I believe, is Lake and Riley Act violations. So that's folks who entered without inspection and have been sometimes merely arrested for a certain crime, like theft, like in the hypothetical. So the Lake and Riley Act was really a sea change because it allowed people who had not even been convicted of any crime to be subject to mandatory detention. Um, and similarly, the good moral character conditional bars, the criminal ones often require a conviction. And this is kind of a way for USCIS to, sneak in mere arrests and say that that is a problem for good moral character. And then we saw the decision um, from the BIA last year, Yahari Hurtado saying that folks who entered without inspection are subject to mandatory detention. So I think this is USCIS trying to say that if someone entered without inspection, that's going to be a problem for their good moral character. And the Fifth Circuit, I know not all of you are in the Fifth Circuit, but the Fifth Circuit did actually uphold that determination. I think there's arguments against, especially if the person was never actually detained. Like, I'd argue they shouldn't be able to use that against them. But I think that that's what they're getting at there.
But the 11th Circuit went the other way, right?
Yes.
Yeah. So some of you are in the 11th Circuit. And also, just to add on to your answer to that question, in this case and in this discussion, we're talking about mandatory detention under the immigration law. So we're talking about a provision of the INA, the Immigration Nationality Act, that would require the Department of Homeland Security to detain someone if certain conditions were present. And this Lake and Riley Act enlarged those conditions to kind of a degree that had never been seen before, to include arrests for things like shoplifting. So that's a very good example, Kelly, that you raised.
I think, yeah, thank you, Christina. That was really helpful. I think in the interest of time, I will turn it over to Christina.
Yeah, and I will try to get it through this next section because I see the new questions coming in and want to give us a little bit of chance to address that. So we're moving now to 1367 Policy Manual updates. These were published on the same day as the VAWA, so-called VAWA updates, and they were also made effective as of the day of their release, December 22nd, to all pending and newly filed applications. Most practitioners who've worked with survivor-based immigration remedies for a long time have known 1367 protections to be very broadly applied to essentially prevent USCIS from relying on any information provided by the abuser in order to make determinations about the application and to protect against the abuser's efforts to manipulate the system and also to protect information shared with USCIS in survivor-based immigration applications from other agencies, kind of broadly. There was not really a reason to think about it much more than that. But in these policy updates, USCIS has changed its interpretation of the language at 8 U.S.C. 1367. So let's go to the next slide. This slide shows what 1367 actually says. And again, it was previously applied much more broadly. But really what it actually says is pretty narrow. The two key statutory provisions, one is the prohibited source provision, known as the prohibited source provision. That's at A. It's the prohibition on the use of information furnished solely only by an abuser or trafficker or perpetrator. Prohibition on using information furnished solely by an abuser to make an adverse determination of inadmissibility or deportability. There's an exception here for non-citizens, survivors who are convicted of certain crimes. So, and under that exception, that information can come in to the determination of the non-citizens or the survivors' inadmissibility or deportability. So we'll talk a little bit more about that. The second is the prohibition against disclosure of information referring to the protected person, that's the survivor applicant, to anyone outside of DHS, DOJ, or the Department of State, again with some limited exceptions. Previously, as I said, USCIS viewed 1367 as prohibiting reliance on information provided by an abuser, such that any information provided by them was viewed as inherently suspect for basically all purposes. That USCIS would have to obtain independent corroborative information from an unrelated and not prohibited source before using it. So this is the most significant, I would say, policy manual change. Previously, also, I think the protected information material was applied similarly. I think most people just misunderstood that information sharing among the sub-agencies of DHS could always occur. So we're at the next slide now. So what's significant about the new guidance is that it no longer reflects the view that information provided by an abuser is always inherently suspect. What it means is that when it comes to the elements of relief, such as good faith marriage, that don't have to do with inadmissibility, abuser provided info can come in. And the policy manual says that adjudicators can consider that information without requiring or seeking independent corroborating evidence. Filers who receive RFEs or NOIDs or decisions relying on derogatory information provided by an abuser should cite to the policy manual language about derogatory information and argue why it would be erroneous for USCIS to rely on that information because it's not credible. They should attack essentially the credibility of information provided by a formerly prohibited source. So it's going to be important for folks to FOIA and request to USCIS to provide the information in accordance with that section of the policy manual that deals with derogatory information and the process around it. That's at the site. I'm going to throw in the chat here. Um, and there's also a regulation that uh, says that an applicant should have an opportunity to rebut any information of which they were not aware in a USCIS adjudication. I'm going to put that here. The provision also, as written, let's go to the next slide, includes this weird exception that allows DHS to consider abuser-provided information for admissibility purposes if the beneficiary has been convicted of an offense under INA 237A2, even if that offense has nothing whatsoever to do with the information being provided or the application being filed, or even if the beneficiary's propensity for truthfulness. It's also weird because this provision at 237A2 relates to deportability, not inadmissibility, and survivors applying for VAWA U or T relief are usually affirmatively seeking an immigration status, not defending against charges of deportability, except in the VAWA cancellation context. So these are what's on the slide here are the offenses that are included at 237A2. So if you look at the actual statute, 237A2 covers more than criminal convictions, includes non-criminal grounds and admissions as well. But for the purposes of this exception, we're only looking at grounds that require convictions. These include crimes involving moral turpitude, aggravated felonies, controlled substance offenses, except for a single offense of simple possession of marijuana, firearm offenses, and crimes of DV. Although 237A7 allows a waiver of DV-related deportability where the survivor was not the primary perpetrator of DV. So I would argue for this related waiver to be applied whenever it can be if DHS cites to this exception for 1367 and in the course of doing so relies on information provided by an abuser. Another thing that we've noted is that several of these offenses, because they relate to deportability, include after admission language. As we don't yet know yet how courts will apply this exception or really how it will come up even, but we urge folks to cite the text if they need to and argue that if their client has not been admitted, the subsection should not apply. So the ground should not apply. For those who were, so the exception should not apply, rather. For those who were admitted on valid visas and overstayed, I would also cite the within 5 years limitation for crimes involving moral turpitude, CIMTs, where that's applicable. So again, it's not clear how much this new reading of 1367 and its exception is going to come up in cases, how transparent USCIS will be about the information it's relying on. But here we wanted to give you some tools to push back against potentially where this comes up. So I'm going to move. Let's go to the poll. Let's get to the next slide now. Here we have a poll. We're going to sort of like test how I did explaining this. So Sandra was admitted to the U.S. with a student visa and was later convicted of cocaine possession. She's married to an abusive U.S. citizen and wants to file a VAWA self-petition. Can USCIS determine that Sandra is deportable based solely on the information provided by her abusive spouse? Okay. So to answer this question, I will say you would need to take two steps and pretend, first of all, that DHS won't find out about the conviction through biometrics. Um, but first, you need to go back and look at what the prohibition is. Once again, it prohibits DHS from using information provided by an abuser to determine inadmissibility or deportability. So under the first step, USCIS would be violating 1367 to determine that Sandra is deportable based only on information provided by her abuser, right? But then you have to look at whether the exception applies. For the exception to apply, Sandra needs to have been admitted, check, and be convicted of a deportable offense, a controlled substance violation, check. So and in the imaginary world, where DHS wouldn't already know based on biometrics, or given that this is a VAWA, the good moral character, shoot, they would know. Um, um, Here, USAS could rely on abuser provided information to determine um, that she is deportable. So that's pretty weird, right? It looks like the answers to this question were split between yes and no. So I want to, um, I think it'll be helpful, or I hope this doesn't actually happen, but I think once we see some manifestations of this sort of weird new interpretation of 1367, then we can probably more easily talk about how it comes up and how to defend against it. We have one more poll for you. Right. Then the second poll, right? Ali is married to Soraya, and Soraya is an abusive LPR. He does not have any convictions. Soraya has frequently threatened to call ICE on Ali. Ali filed a VAWA self-petition and is worried that USCIS might find that his marriage to Soraya is not in good faith if she calls ICE and says that he only married her for a green card. Are Ali's fears well-founded? Let's see. So it looks like most people who are responding are saying yes. Unfortunately, I agree. The question again asks us to review the prohibition. And again, the prohibition means that USCIS can't rely on her allegations, to rise allegations, to determine inadmissibility or deportability unless Ali has been convicted of one of those crimes. But he has no convictions, and so we don't need to worry about the exception. Thank goodness. But what is at issue here is, well, potentially fraud-based inadmissibility. But in the VAWA context, the consideration would also be good moral character. What else? A necessary element of the VAWA eligibility analysis, right? Good faith marriage. Good faith marriage is not a ground of inadmissibility or deportability, but so the prohibition, the new reading of the prohibition doesn't apply at all. There's no prohibition on negative information provided by Soraya. This example illustrates the true harm of the policy change. Would allow abuser provided evidence to come in for eligibility purposes and be treated like any other kind of information. Um, so even so, USCIS would still need to consider if there are indicia of credibility, and the abuser provided information can still be challenged as not credible. Makes it even more important to do as Kelly suggested and bolster the credibility of your client's testimony in their affidavit. Let's go to the next slide. And then I think we'll hopefully have just a couple minutes. I'm gonna go quick. So USCIS has stated also in these updates that the registration and change of address requirements apply to protected persons, and the protected persons are not excused from providing physical address where required on all the forms. All the forms do require that now. I've heard a lot about rejections of applications that were filed with confidential in the physical address section. I've heard of other cases where they've seemingly been receded. I don't know what's going to happen later on in the adjudication process, but I will say that if a client is in a domestic violence shelter with a confidential address, I think it's fair to continue indicating that they are at a confidential location, and I would obtain a letter from a case manager or advocate explaining this on their letterhead and submit it along with that. Also in these updates, USCIS stated that these protections end, the 1367 protections such as they are, end when the person naturalizes. USCIS has implied that attorneys or accredited reps also can call the contact center without the non-citizen, which is the one bright spot in all of this. Let's go to practice tips, the next slide. And I want to here, I do want to talk a little bit about the new adjustment memo and how it will impact VAWA adjustment. Um, and But first, though, I want to let people just take a look at this slide. We do recognize that the prohibited source provision will be applied not narrowly, that some criminalized survivors will receive no protection against adverse information provided by their abusers, that information provided by abusers, etc., is not credible, that needs to be argued. Consider retroactivity once again. Prepare arguments on why certain criminalized survivors should still be protected based on the language of that provision at 2372. And definitely take a look at those derogatory information provisions and make sure to request information if you learn that it has been considered. Okay. I'm going to turn it over to Kelly now to answer that question that was asked in the chat about the new adjustment memo, which some folks who, if you don't know about it, there's a new memo that came out just this past week where USCIS indicated that it would be diverting many adjustment of status applications to consular processing, except in exceptional circumstances. Go ahead, Kelly.
The question was, do you anticipate the new adjustment/consular processing memo will impact VAWA adjustment? So my colleague Rebecca put out a really good alert to the listserv about this last week. It was last Friday. She pointed out that, the memo says, it focuses on the fact of whether consular processing exists. It does exist for VAWA adjustment. But the memo also focuses in terms of their justification for disfavoring adjustment of status. It focuses on characteristics that they allege show a congressional intent to disfavor adjustment, and those are primarily the 245C bars to adjustment. But my colleague Rebecca pointed out in her alert to the listserv that the 245C bars, so for example, unauthorized employment, not being in valid status at the time of filing adjustment, those bars don't apply to VAWA, so that rationale shouldn't apply to VAWA adjustment, because actually, as opposed to there being these restrictions on adjustment, like there are for family-based cases, there's actually plenty of exceptions in the INA that favor adjustment for VAWA self-petitioners. I think it remains to be seen how they will apply this in practice. But my colleague has said, and I agree with her 100%, that adjustment is discretionary, so it's important to include that evidence of positive equities, even in cases that in the past might have seemed relatively straightforward, even when there is no criminal history, even if there is, one entry without inspection 20 years ago, like still including that evidence is going to be really important and highlighting, I think, the harm of removal and having to return to home country. And I think also if the client is from a travel ban, or not, like, what am I trying to say? Immigrant visa ban country, was it the 75 countries? I think that's also
Yeah.
a highlight that actually no, they can't consular process because immigrant visas from that country are banned. And as that is written, there is no exception for VAWA-based immigrant visas. So I think that's something you can point out if that applies to your client.
That's right. And then we also believe that there's a footnote, was it 15, I think, that suggests that U visa adjustment candidate applicants are also exempted from um, the sort of directives of this memo. But this is just now being implemented also, and we're slowly, as information is trickling out, practitioners are sharing what they're seeing at the adjustment offices, and the kinds of intel that's sort of being shared by USCIS officers who are interviewing folks. So one thing I saw recently was that a USCIS officer said the interviews will continue, but decisions will not be made until they get further instructions. So I think we should anticipate that additional guidance is coming down the pike, and to sort of stay vigilant and keep an eye out for that. I believe that USCIS is continuing to schedule interviews for VAWA self-petitioners who have applied for adjustment of status, and are continuing to inquire with them about the bases of their applications. They believe, I think the interest there is in confirming that the applicant understands what is in their application, and that the application is made, with their full knowledge and agreement. And for those of you who are, tough to say this in the last minute, for those of you who have clients who are VAWA self-petitioners who have advanced parole, we are seeing also increased scrutiny of folks who are returning to the United States on advanced parole stemming from their VAWA self-petitions, with some folks even being turned back. So I just want to put that out there as well. So for folks who have clients who are considering traveling on their advanced parole, feel free to reach out to us to talk further about what we're seeing, so that you can make sure to advise them appropriately.
Thanks, Christina. We'll go to the next slide. And
right. More questions. I jumped the gun on my question.
No, that's
takeaways. Yeah.
So just keeping in mind that USCIS guidance on the any credible evidence standard makes it really important to include these arguments and evidence on domestic violence dynamics, and that you review your filings for consistency and credibility. As Christina, underscored with her presentation, unfortunately, fewer immigrant survivors are going to be protected by the prohibited source provision. If USCIS tries to use a statement of an abuser against the survivor, or if you think that this might come up, prepare arguments about why statements provided by abusers are not credible, and also prepare to address any improper determinations that the survivor is the primary aggressor, and also include copious positive equities evidence when there is any hint of a good moral character issue. Next slide. Thank you all for participating. There is going to be a survey that pops up at the end of this webinar. Please take a moment to fill it out. We'd really appreciate it. We do read all of your responses and they help us plan future trainings. So thank you all for your participation. And I hope you all have a great afternoon, and thank you for being in this fight with us.
Thank you, guys. Thanks, Kelly.